Okay, thank you all very much. We're going to kick off. We're slightly late. I'm Jennifer Baker. I'm a journalist and I will be the moderator, just trying to keep things going. But we do want a lively discussion. So there's a microphone in the middle of the room. So once our panelists have sort of set out what their positions are and the state of affairs in the various member states, we've got representatives from Netherlands, France and Germany and the UK on this panel. So I would really encourage you to stand up and ask questions and really challenge them about the future of justice in the surveillance age. First of all, I'm going to hand over to our chair to make some opening remarks, and that is Peter Wright, who is from the Law Society of England and Wales, who are hosting this panel, and he will tell you a little bit more about that before I introduce our other panelists.
Thank you very much, and good morning, everyone. Welcome to the panel. It's organised today by the Law Society of England and Wales. We represent 160,000 solicitors across England and Wales, so we're the main professional body. And we've been very heavily engaged in working to try and ameliorate some of the effects of some of the acts that the current government has been trying to introduce, namely things like the Investigatory Powers Act, which has just become law in the United Kingdom. As part of that, we did a lot of work to try and protect things that lawyers find quite important, things like legal professional privilege, which sometimes gets forgotten or ignored, very often even by clients, I tend to find, but it's something that lawyers value very, very importantly. The fact that communications between lawyers and their clients should indeed be private, and the fact that an individual has the right to receive legal services and legal advice without having anyone else look at it. It's quite a fairly fundamental right, you would have thought. However, in the initial version of the Act, when it was published, and I was going to bring a copy of it all for you here. Unfortunately, I came on the Eurostar yesterday, and there's a limit on the amount of baggage you can bring through. So unfortunately, I had to leave that at St Pancras. But you know, it's a very, very large piece of legislation. You would have thought, in the original draft version, they would have found a space in there to protect things like legal professional privilege, but they hadn't. There wasn't even protection for journalists to be able to protect their sources. Again, a fairly fundamental right, but no, under the original version of the Act, you would have found that even a journalist would have had to potentially find that their communications with sources could have been looked at by the government as well. So quite fundamental effect there when you think about it in terms of rights and privileges that we've tended to take for granted in recent decades. So we spent the best part of a year lobbying the government, and the government was trying to push this through at fairly breakneck speed because of the political climate in the light of things, of some of the security threats facing Europe. Then this was a piece of legislation that originally would have taken about 2 years to work its way through Parliament, but because of the perceived security threats, was being pushed through at breakneck speed. So we had to find experts to lobby for us in Parliament, experts who would be able to really highlight to politicians the fundamental nature of these rights and why they were something that is actually worth fighting for, and certainly why we felt it was very important to fight for them. So we were successful in actually getting some protection for legal professional privilege on the face of the Act. Certain people have said, well, look, shouldn't we have actually had greater protection being able to be secured, and felt that it was still a bit of a disaster that the Act has come into law in the way it has. But we felt that no, the fact that we'd actually got this recognised in surveillance legislation for the first time to give some protection to lawyers and their communications with their clients was a victory in itself, and we've had to think, well, we'll take any victory that we can in that nature. But the nature of the Act is a very far-reaching one. One of the things it requires is for all internet service providers to keep records for a year on all of the pages that each IP address has looked at during that period. Which is quite fundamental when you think about it, in requiring organisations to store that sort of data, just in case government wants to take a really good look at it at some point in the future. So, you know, when you sort of think about that, it's again, very fundamental. There's been a lot of lobbying about it, but it's still something that has ended up now taking place. When the government was saying, well, look, this isn't something necessarily we're going to end up using in a particularly large volume. Look, we only made 60 requests in the last year under the previous legislation. That's not much, is it? But then you look at what the nature of a request could be under this legislation. A request could be, we would like to look at every single email sent by anyone within the United Kingdom for the last 12 months. That could be one request. These bulk data requests can be very, very large in nature. So just think, oh, we've only used this legislation 60 times in the previous 12 months, actually reveals a very large level of state surveillance. There is a problem at the end of all this, though, and that's that lawyers get very animated over things like legal professional privilege, as you can probably imagine. Privacy campaigners get very worried about issues that some of the freedoms that were potentially being infringed on by this. But the wider public don't tend to engage. You can try and, when you even look at coverage on this in the press, they aren't particularly interested. If anything, they're saying, we need all of these protections to guarantee our security, which is a fair argument. But very often people are accepting this without understanding the freedoms that are being lost. And that's where I think there needs to be a public debate, certainly in the United Kingdom, with regards to exactly how far this should go. So it really is a matter of, and that's where the Law Society is trying to encourage an element of public education on that, to try and ensure that the public is more informed on this. So if you are interested by a lot of the issues that we end up talking about today, please feel free to take a look at the Law Society website. It's lawsociety.org.uk. We don't just have minutes of meetings in dry, dusty rooms with people wearing suits talking very earnestly about things. We have some quite interesting videos. We had a conference on artificial intelligence at the Law Society last year. That was recorded. It's up on YouTube. You can take a look. It's got me talking at one point about artificial intelligence, if you're interested in that sort of thing. And we also have some reports, in particular one on capturing technological innovation, which looks at things like the provision of services legal services through an online court, which is going to be happening in the future, in very near future in the United Kingdom. Things like fintech, things like innovation hubs, robotic process automation, all these things are going to be covered. So if you are interested about all the issues that come up today, please feel free to dig a little deeper in some of the reports that we have on the Law Society website. Anyway, I'm going to hand over back now to our moderator, and then we can hear in a little bit more depth from the rest of our panel.
Thank you very much, Peter. Thanks for that introduction. And I would say this is Cpdp, so we all know lawyers are not dusty old suits. You're our heroes here this week.
Just for once. Yeah.
So first of all, slight change to our lineup. Sir Michael Burton can't make it due to the vagaries of Eurostar, but we have a very able panel. We have Margarete von Galen from the German Federal Bar, who will tell us about the German situation. Nathalie Moreno from Silkin, and you, I believe, will focus more on the French situation. And next to me, Nico van Eijk from the University of Amsterdam, who will focus on the Dutch situation, not surprisingly. But Margaret, let me start with you. Tell us a little bit about the situation.
Yes, thank you very much. As you already said, I am going to focus on the German situation. And I think when it comes to the question of how the future of the justice system is going to develop in the age of mass surveillance, it is very important to have a look on the legal profession and which role the legal profession can have, may have, must have in these future developments. And in Germany, we have a law which explicitly rules that the attorney is an independent agent in the administration of justice. So I think this is also the understanding in the other member states of the EU, although it might not be stated explicitly in their laws. And as we all know, and my colleague already pointed out, one of the cornerstones in practicing the legal profession is the duty to observe and the right to maintain professional secrecy. And it's obvious that surveillance is a threat to this core value of the legal profession. In fact, not only a core value of the legal profession, but also and primarily a right of the citizen to confidentially meet a lawyer and obtain advice without being observed in the process. Germany has a rather far back-reaching history of, concerning the fundamental rights to privacy and the right to protect personal, to have personal data protected. And I think it's interesting for the whole context in Europe and beyond to have a look at our, the first mark of case law in Germany. This is a 1983 decision where the Constitutional Federal Court in Germany really created a new fundamental right, which is, if I translate it literally, the right to informational self-determination. So since then, we deal with this right to informational self-determination, which is a special form of the right to privacy, focused on the protection of information concerning the private life of the individual. And the right means that the individual has a competence to determine the disclosure and usage of his or her personal data. And this is a right which is not explicitly mentioned in the German constitution, but was developed by the court as a direct outcome of the general right to privacy and personality. And already in this judgment, the Constitutional Court stated that, or the reasons why the Constitutional Court created this right were that the court saw a threat to democracy if surveillance would go beyond or would intrude too much into the private life of the people. And the court found that if people were too much surveyed, they could adopt to this situation and they could refrain from exercising their fundamental rights, such as freedom of assembly or freedom of association. And at this time already the court said you have to weigh these values against each other, and there is a threat to democracy if you intrude too much in people's lives. In the years after this decision, our federal court had, unfortunately, many occasions, or some occasions, to rule on surveillance and to repeal laws which were made in Germany. This was in 2004, the court repealed eavesdropping act concerning eavesdropping in private living space. In 2008, the court repealed a law concerning online searches. And in 2010, well, I think according also to the European case law, the Federal Constitutional Court repealed an act which ruled the detention of data, which also gave rise just recently to another decision of the ECJ. And I think concerning the legal profession, the most important decision in this series is a new ruling from April 2016 on a new Federal Criminal Police Act. This is an act which regulates the powers of the police in the stadium of prevention of crime. It has nothing to do with investigating criminal offenses, but just with prevention. And the court ruled that some of the general rules were unconstitutional, disproportionate, because they have not balanced in the right way the impact of the intrusion and the right to privacy. And especially concerning the legal profession, the court criticized that in this law there was a distinction between criminal defense lawyers and other lawyers. So the law provided for a strict protection of criminal defense lawyers. It said that there must be no surveillance of criminal defense lawyers whatsoever, for whatsoever reasons, not for security reasons, terrorism. All these aspects may not give cannot justify surveillance of criminal law or criminal defense lawyers. And concerning lawyers who work on other fields, there was not this strict prohibition of surveillance, but the question whether other lawyers could be surveyed was object to a proportionality test. And there our court says, well, this is not a constitutional and not a proportionate distinction. All lawyers should be handled equally, and the result was that the Constitutional Court said that all lawyers should be protected against surveillance, regardless if they are acting as a criminal defense lawyer or if they act on other fields of law. So this is really a very important step for our German culture concerning the respect of the legal profession and the legal privilege. And well, we see what is the outcome in practice on the long way. Maybe so far, or shall I?
I think let's hear from Nathalie about the French situation,
okay.
And we will come back, I'm sure, to more details from you.
Good morning, everyone. So the French law on intelligence is a very specific case. It was produced right after the attacks at the Charlie Hebdo's offices in France back in January 2015. Obviously, the objectives of the French government at the time were to take back control because they thought that the existing legislation was outdated and they needed a serious update, not only to get back control, but also to be more in line with the existing communications technologies. As a result, what is in this law is probably a reflection of what was to come in the UK in terms of the Investigatory Powers Bill. 4 points which will be important to bear in mind about what this intelligence law established. First, the purposes of the intelligence law are very wide. You would think that the government would have powers only related to the protection of national security interests. Well, the objectives are a lot wider. That the law actually authorizes intrusive surveillance powers for broad and undefined goals such as major foreign policy interests or protecting France's economic, industrial, and scientific interests, the prevention of collective violence, and organized crime. So you see, the scope of the law is way beyond what other countries have produced for intelligence powers. Another very controversial feature of that law, and there's many, unfortunately, was that for the first time, the state was authorized to use mass surveillance tools that capture mobile phone calls and black boxes from internet service providers that collect and analyze the personal data of millions of internet users. So it's hard to understand what would be the justification to basically analyze the entire personal data of the French population, although on an anonymized basis, for which particular purposes. We can see what type of lack of scrutiny may apply to that type of practice. The third, probably controversial element of this law is the powers which are granted to the government. There is a specific commission which is established to deliver decisions on what should be authorized or not authorized, which is important to know. However, the Prime Minister can override this decision, and there is no control over any of the Prime Minister's decision. So if the Prime Minister decides to undertake for investigations for a specific operation against a terrorist, suspected terrorist attack, there is nothing to stop him. And the Commission's decisions are not binding on the Prime Minister. So you may argue that in any democracy there is always the possibility to appeal to the highest court. In this case, the relevant court would be the administrative court. It is in theory possible, but one may question to what extent that would happen in practice. And then, in the overall, that law, when it was first produced and submitted in Parliament, raised such an outcry that the President was forced to refer it to the Constitutional Court, so that there's a final decision whether or not these new powers of control, mass surveillance practices were constitutional. And in that context, that's where the legal profession and other associations representing journalists, for instance, came on board, arguing that the law was breaching the law of secrecy and confidentiality of correspondence for lawyers and journalists, and so on and so forth, and they made their plea. Unfortunately, the Constitutional Court decided that because the law does not give powers over the content of the correspondence, but only to the logs and other IP data, that was not a breach of the duty of confidentiality and secrecy. So here we are in a situation in France where we have a law which at the time when it was adopted back in 2015 was actually considered even more intrusive than the US Patriot Act. Since then, obviously, we had the UK Investigatory Powers Bill, and then we're entering a new era where mass surveillance, which was once considered a breach of privacy and individual liberties after the reports of Edward Snowden back in 2013, we have now these practices becoming not only normalized, but to a large extent, totally legal.
Okay, Nico, is the situation any better in the Netherlands?
I don't know whether any one of you had the time to do your regular YouTube search. There is a little video that has really gone viral. I believe there are now more than 4 or 5 million people that have seen it, where a Dutch comedian offers an insight in the Netherlands, especially for Donald Trump. And the goal is that if the US should be first, the Netherlands should be second. So I get a lot of inspiration from the United States. So when you look into mass surveillance, it was just mentioned, we have the famous Snowden revelations, but those revelations were actually preceded by having this instrument called the Patriot Act. And we were in a position to study the Patriot Act before the Snowden revelations, and we could not define the extent of the law. It could be like everything between 0 and 100. We could not imagine that this law would allow, it's actually a package of changes in legislation, that this law could allow any form of surveillance, mass surveillance, foreign surveillance, without restrictions. And then the Snowden revelation showed that it was not between 0 and 100, it was between 100 and 150%. I was very touched when I heard one of the authors of the Patriot Act saying, and let me quote, "I was the principal author of the Patriot Act. I can say that without qualification. Congress never did intend to allow bulk collections when it passed Section 215, and no fair reading of the text would allow for this program." That really inspired me, and I was even more inspired when I read the successor of the Patriot Act, the USA Freedom Act. Because in this act you find some very interesting changes in the US system. First of all, it confirmed that all surveillance matters needed prior consent of this often called secret court, the FISA courts. But the courts themselves already signaled that they felt that they needed more expertise to take that kind of decision. So in the USA Freedom Act, there is a provision that allows the court to appoint special experts, amici curiae, on the topic of fundamental rights, on topic of technology, on surveillance, and these experts have now been put in place, and they have full access to all files, and they support the court in its decision-making process. The FISA court was also very unhappy with this idea that they were considered to be a secret court. So the USA Freedom Act also has provisions that obliges the court to be as transparent as possible. There is an obligation of the court to declassify decisions as quickly as possible and to make them available on their website. And this is really, really fascinating. This is a court with its own website, with statistics about the decisions it takes. Also about the orders that were rejected. It's a relatively transparent court, and I have never seen that kind of transparency even with ordinary courts in many European countries. There are also similar obligations to the government to be transparent, and it also gives a legal basis for transparency reporting by third parties, like companies who are somewhere involved in the whole surveillance business. Why am I telling this? I'm telling this because I think this should be the bare minimum that we should have in Europe. However, most of the proposals, including the proposal that is now pending in the Dutch Parliament, do not even comply with this bare minimum. So, to give you a few headlines of the new act that is that what we are now discussing, it only requires prior consent of the courts in 3 limited cases: in the case of access to written letters, in the case of the lawyer-client confidentiality situation, and in the case of protection of sources of journalists. In all other cases, so when it's not about letters, when it's not about lawyers in another capacity than the relationship, the confidential relationship with their clients, when it's not about journalists seeking protection of their sources, in all those other cases, a new committee that doesn't offer the same level of comfort or guarantees as the ordinary courts will be the decision-making authority, where orders by the security agencies, or actually, and I find this also quite interesting, in the debate we are always focusing on the security agencies. However, the security agencies are only the executor of decisions mostly taken by a minister. It's the government that is responsible for surveillance, it's not the agencies. So the Dutch minister has said, okay, I know I have all these powers, and yes, unfortunately, due to the decisions in Strasbourg, we now have to allow the courts to have an opinion and to authorize certain orders, but I will do my best to take the best decisions possible. Therefore, I will extend my staff. And I've argued that's actually the totally opposite of what you should do. You should enforce courts. You should enforce those who are responsible for checking what you are doing. And this brings another very interesting topic on the table that is in many countries completely ignored. That's the fact that you need sufficient resources. Decisions in Strasbourg have over and over again made clear that rubber stamping is not allowed. If we are going to extend the powers of the government in the context of surveillance, and that's one of the other elements in the new Dutch law, it becomes technology neutral. That sounds always very nice, but it actually means that all wired communication now is falling under this law. So That includes access, if of course granted, to internet exchanges, to all types of internet access. And I can imagine that you're in favor of this kind of technology neutral approach, but then you need to have a good system of checks and balances. And so we do extend the capabilities, but we do not compensate that with sufficient checks and balances, like courts that have the resources to be truly effective, courts that have the appropriate expertise. And we are very puzzled by why do we have courts and a new committee? Why is it necessary to make this separation? How can you even turn this into something practical? Just imagine the situation that you're listening to the communication of a journalist and suddenly the journalist talks about a source. This is a decision that in first instance needs the authorization of this new committee, but you hear something about the source. That's the competence of the court. How are you going to deal with that? So all these very also practical things in how to protect people, how to protect these special professions is very, very unclear. And the law is a very thick law. The accompanying text is even worse. It's like almost 300 pages. We now have the answers of the government to the questions of Parliament. It's another 120 pages. And I'm very puzzled by the fact, how is it possible that you can fill hundreds of pages without answering these very fundamental questions? I'll leave it to you.
Okay, that's a good question. But let me first, we've heard sort of rather horror stories from Germany and France. But you're suggesting that maybe looking to the US, which sort of turns on its head what we generally think of as, it's not what we're hearing in the other rooms.
But I can ask people in the room, who has ever read the US Freedom Act? And I don't think I've seen many fingers, exactly, 2, 3, 4. So we're ignoring what's happening out there. We are very much focusing on Europe. We think we are completely politically correct, but there are also very, very interesting developments in the US. There's also a lot of horror in the US system. I don't want to ignore that, but there are some very interesting examples that I just mentioned that we are not aware of, and I think that could be really good input for national debates in Europe.
Well, let me put the same question to the other panelists. Do you look to the US with hope in your eyes? Peter.
Well, one thing, I'm just looking at the US, funnily enough. There's been enough happening in the course of the last week, really, of course, hasn't there? Because in the flurry of the executive orders that President Trump has signed, where I think someone should have told him, you can pace yourself, you've got 4 years, in theory. You don't have to do it all in 1 week. But one of the things he signed was an executive order on immigration. Buried in that, at section 14, is the following text. Privacy Act. Agencies shall, to the extent consistent with applicable law, ensure that their privacy policies exclude persons who are not US citizens or lawful permanent residents from the protections of the Privacy Act regarding personally identifiable information. Does that blow a hole in the privacy shield? Arguably it does. And therefore, in terms of what can we hope for from the US? Well, there you are. That's exactly what we're going to get from the US. And the implications of that are then immense when, obviously, we know how much information is always going to be going back to the US. But just ask yourself about something like Windows 10. The vast majority, an awful lot of information that picks up, everything from what people are looking at, the data, the programs they're using, even what it's recording through the AI on there, Cortana, in people's offices, could be then squirreled back to the US. I know an awful lot of law firms that use Windows 10, and they're saying, are we breaching confidentiality by using this? Now, of course, they have to use Windows products because that's what everything else works with. Compatibility and everything. But are we going to end up saying to people, look, you can't actually use Windows 10? It's a really tricky area. I must declare an interest. My wife is actually from the United States, so we follow US events quite closely. Made last November quite interesting, you can imagine. But I'd like to think that we can still look with a degree of hope in terms of the direction of travel in the US, given what happens in the US obviously affects what we're doing in Europe and the rest of the world. But the initial signs aren't good, I suppose.
Margarete?
Well, I think I just have to agree. I'm not going to repeat what you said. And Well, I think the US are a problem, or, well, there was a very short time space when we thought the problem was solved concerning the data transfer. Now the problem is on the table again.
Yes.
Well, we all have to wait and see how the development in the US is going on. And I think that there's also enough reason to focus on the European development. I mean, we just have the new proposal from the Commission concerning e-privacy, and I think, of course, we all understand this need for new regulation because of the terrorism threat, which cannot be denied. It goes without saying. But what I would criticize concerning the EU legislation is that if we speak about the legal profession, the legal profession doesn't occur in these proposals, and sometimes for instance, in the general data protection regulation, it was possible to negotiate one small provision into this regulation, but normally, I think what I see, the legal profession does not appear, and I think this is not the right approach if you think of the judicial system. And I think it goes without saying that judges are not object or subjects of surveillance, but the legal profession is dealt with like other citizens. And I think in this regard, there should really, well, I would demand a change of culture in the European, well, lawmaking bodies concerning this aspect.
And do you think that's deliberate or just oversight?
It's difficult to say. I fear it is deliberate.
Nathalie?
I just had a thought about the EU-US Privacy Shield. We all know it took ages to actually come to an agreement with it. And in any case, the agreement was reached with the view that the arrangement could be reviewed in a year from now. Some countries, such as the UK, were very instrumental to help to reach that agreement, because all the debate around mass surveillance and so the ability of the US government to reach and be able to access personal data in the EU was a big issue. I wonder, in a year from now, after 1 year of Trump's presidency, how things are going to evolve and what will be the positioning for the EU. EU minus, in weight, not visually, but minus UK.
Nico, do you want to predict?
I think you have to, when it comes to these kind of topics, you first of all have to put America first, but then America is the Netherlands, Belgium, France, whatever. We can criticize the US, but we have incredibly weak systems of checks and balances. We have endless decisions by the court in Strasbourg about surveillance. We have had a second data retention case, and again, the court has confirmed its earlier case. We have to realize that with the data retention case, what the court did was it said the European Commission was wrong, European Parliament was wrong, European Council was wrong, the Dutch government was wrong, the Dutch Parliament was wrong. That's a real crisis. That's a real crisis, and I don't see a lot of improvement. To some extent, I mean, there is a problem between Europe and the US, but how can we actually even discuss that problem if the UK intelligence agencies are spying on Belgium? I mean, in the US they don't have a Texan FBI or a Californian FBI. We don't have even reached a situation within Europe where we have a kind of common denominator in this field. And that, to my, that's where I see a kind of fundamental flaw in the debate. We are pretending things in this relationship that we don't comply with in our own country, in our own jurisdictions. And the national security issue is still an issue that is that belongs to the sovereignty of states. Therefore, this is actually not a EU problem. You can try to turn it into an EU problem, but basically it's the whole little thing in the privacy shield is about what is happening with information when it comes to national security and surveillance. And that's outside the scope of the European Union. That's where countries themselves should step in, and maybe we still have to go to a process of bilateral agreements on this, because I don't think that the privacy shield will survive. And I'm also very skeptical about anything else that we try to do at the EU level. And we should definitely not use the e-privacy directive for this debate. I mean, this is where the nations of Europe have to negotiate with the US, and where they have to negotiate with each other. Because based on the decisions of the court in Strasbourg, in Luxembourg, it is forbidden to exchange data between certain countries in Europe, because they are just not compliant with the fact that, for example, an independent judge is involved in the whole process of surveillance. There is this report by the Fundamental Rights Agency of the European Union that has a nice table that shows that there are, like, I believe 7, 8, 9 states that not even have any form of involvement of courts in the decision-making of surveillance orders. Well, that's even worse than what we are trying to put in the privacy shield.
Well, let me turn that to the others. I mean, after Safe Harbor was struck down, there were many in the US who accused the EU of hypocrisy because they didn't understand this separation. So, I mean, how do we get around that, Peter?
Well, it's funny. I wrote an article a few months back, just before the Privacy Shield came in, saying Safe Harbor lasted for 15 years. It's a bit of a miracle, really, when you think about it. It was only a sticking plaster over a bigger problem. And I thought, at the time I wrote, well, Privacy Shield will last for a few years. It will not last as long as Safe Harbor. I didn't think it would. I thought it'd make a year, though. I thought we'd get that far at least, but arguably after this week, maybe we haven't. And it is a massive issue that has to be properly addressed. And when you look at the mechanism that led to the Privacy Shield coming together in terms of the hoops that the White House, the last administration, jumped through to satisfy what the EU was looking for, I looked at it and thought, this isn't a sound enough basis for people to be able to rely on and use this going forward in the long term. I think it's very difficult to identify what a proper long-term solution would look like, but clearly Privacy Shield isn't it. And in terms of what we eventually need to work towards, who knows? The fact that we've now got a very different type of administration in the US that seems much more business-like, wanting to get things done ridiculously quickly, who knows? Give them a constructive solution, maybe it's something that they'd accept. I don't know. I don't think anyone knows at the moment.
Okay, well, let me ask, does anyone know? Does anyone? Do we have any questions for our panelists? Okay, we have a microphone here in the middle, so. Thanks.
Hello, Felicity McMahon. I'm a barrister in London. I just wanted to build on that point that you made about when Safe Harbor was struck down, many in the US accused EU countries of hypocrisy. And we in the UK now are thinking about, and we thought about on our panel the other day, about what happens when we leave the EU and may need an adequacy decision for data transfers under the GDPR. Given what we've all said, the panel have all said today about the surveillance laws in various EU nations, do we actually think that any EU nation would get an adequacy decision if they had to get one?
Okay, very good question.
Yeah, that point has been made in the debate. By having this focus on what should be the conditions of such a shield, we also have been making transparent that there are many, many other countries where we had safe harbor systems in place and where we now have to question, are we going to find alternative solutions? And this goes from India to Israel to many other countries, and again, because there is this weakness in national security legislation in many countries, indeed, there should be maybe safe harbor agreements between certain member states within the EU. And again, I'm not against surveillance. On the contrary, I'm very much in favor of how the court in Strasbourg deal with that, and where they say there needs to be a good system of checks and balance. We need to have legitimation for these kind of things. And it's not just trying to find a simple political compromise, which is mainly what was done with the privacy shield. We have to go beyond that and have to accept that there is a rule of law and that we have accepted the fact that we have a charter and a European Convention of Human Rights. And that's tough, but we went to a lot of comparable issues during the past decades, and we were able to find solutions, and I think there are solutions.
Yeah, when talking about the way the EU perceives itself in terms of compliance with the best standards of data protection, I think the EU believes that they hold the highest standards. And so in the context of the EU discussions on Brexit, I think it's already been disclosed that the quest for an adequacy decision post-Brexit will be difficult, and in particular in the basis of the new UK Investigatory Powers Bill, which obviously grants huge powers of mass surveillance practices and so on. So yes, I will agree, there's an element of hypocrisy there. And perhaps the debate will be fed by new realizations that actually these are all government practices in all EU countries, not controlled. But I think we need a little bit more awareness to help this not being an impediment for the UK to be benefiting from this decision. But as we know, this is a much wider debate. This will be part of many other parts of negotiations. But from a strictly compliance point of view, I will agree that at the moment there's not enough procedures against the member states which are infringing the existing EU data protection framework.
Okay.
Hi. I wanted to know a bit about the notion of justice. What is just when it comes to the question of online sphere? Because I am an advocate from Bangladesh, it is in South Asia, and for us, justice have two meanings. Like, you can do justice by punishing someone, you can do justice by forgiving someone, by not punishing someone, two notions. So when it comes to the notion of online mass surveillance, suppose a judge in the Supreme Court, he or she got the information to the artificial intelligence even before the lawyers they do argument in the court. That means the judge will be appearing in the court with preconceived notion. It might be. Would not that be jeopardizing the whole notion of justice in the upcoming days if the governments develop their system, judicial system, based on artificial intelligence and mass surveillance and etc., etc. So what would be the notion of justice that time?
Okay, I think we're straying a little bit off topic there.
Or maybe you can, because I think the German Constitutional Court ruled on this issue several times, and well, there's a notion of justice which says that citizens have to have the right to appeal against all sorts of intrusive measures carried out by state authorities, and this has to be an effective legal remedy, which means that the citizens have to get information about what happened to them, at least in the hindsight, there has to be transparency on, let's take the data collecting or retaining issue, transparency on what was collected or stored or whatever, and of course effective legal remedies. So I think on the paper, I would say this is a rather clear rule concerning the German situation, and I will also say the Strasbourg legislation or the Strasbourg case law also is correct in this sense. I think the problem is that in practice, well, people get the information, but much time after the measure has been carried out against them, and then of course appealing against this, it's also a question of costs and so on. So I think between the theoretical level of protection concerning legal remedy and the practical level, there's also a difference, and this difference could lead at the end of the day to the assessment that there is also not everything is just, and there is a lack of justice. I would agree.
And I think just more generally, with regards to justice when it comes to technology and delivering justice using technology. In the UK, we are going down the path at fairly high speed of implementing an online court. The idea being that you'll be able to make massive savings by administering hearings, administering justice through technology. And I think there's a big gap there at the moment in terms of, A, the court system wants to go down that route to save money and to save time and increase efficiency. But you've also got the question of, will the person who's actually gone through that justice system feel they've actually received justice? Will the person who is having to attend a hearing via Skype or on a mobile device online, hundreds of miles away from a court, feel that they've actually received justice? Will people feel that they are in fact being denied justice because they're being told, no, you have to go through this online system instead? It's a fine line to follow, and a lot of the work that we're doing at the Law Society at the moment is to work with the Home Office, which is putting these proposals together to say, look, absolutely, you want to save money, you want to be efficient, you want to perhaps open up access to justice to the 4 out of 5 people who at the moment may have a legal problem but don't go anywhere near a lawyer because they can't afford it, or it's too confusing, or they just frankly don't know how to even start. Will opening up things up and making it, administering it justice online, allow for that greater access, that unmet legal need, as it were? Hopefully it will, but I think you don't want to then find that people feel that they are not receiving that justice and that they are in fact being denied what you would argue is a natural right. That's certainly an ongoing issue that we've got, and I suspect it's going to be, it's something obviously that's being looked at across Europe and further beyond as well.
We're also going to end up looking at things like Ross Intelligence, where it's an actual AI-operated lawyer. So, yeah, a lot of questions to answer. But Marcy.
I'm Marcy Wheeler. I write on these issues under the name Empty Wheel in the United States. And I'm going to be on a panel at 4 o'clock where I'm going to blow still bigger holes in Privacy Shield. So it should be a lot of fun. One of the things that you guys didn't address on the US is the new data sharing rules under EO 12333, which is actually the bulk of our spying. The stuff that FISA oversees is just a fraction of it. And for those of you who don't know, one of the last things Barack Obama did was permit the NSA to share all the data it collects with any of the 17 intelligence agencies in the United States government, including both FBI and DEA, which have a kind of dual function. There is no protection for journalists in there. The protection for attorney-client is basically call National Security Division. So also no protection there. That's just background, but one of the things we're facing in the United States, increasingly on surveillance like that, is that we know the government is parallel constructing evidence that comes into trial. So particularly on any metadata-related program, probably on FBI's mass hacking, which they also got that authority at the end of last year, the FBI will not provide the defendant notice of where the actual evidence originally came from, they'll reinvent the evidence. In one case I know of, they basically got the evidence through FISA and then just got a warrant for Google and for Yahoo, and therefore had a clean route of evidence. So that's one of the concerns that we're having on all of the surveillance stuff. But one of the things I'm seeing as well in some cases are the FBI hiding events in Europe. So for example, I know one defense attorney who's had clients in 2 different cases be named co-conspirators here in cases in Europe and get no notice of that in the United States from the US government. There are things that the FBI can do in Europe and say, well, it was the Netherlands. I know the case where it was the Netherlands that did it, even if it was an FBI legat who was involved in coaching the Netherlands on this. And I'm curious if you guys are seeing any of this from your side. Because I know the US is sort of doing this arbitrage of let's go to Europe, there's less transparency. We can use Europe as a shield for some of our activities and hide it from defendants. So sorry for the long-winded, but that's my question.
Yeah. When I talked about the US, I was talking about things that are, for me, the bare minimum we should have in Europe. I know your stories, in particular, the exchange of information in 2 ways, within a country and between national security agencies of different countries, is something that is going to increase, and not just a little bit, is really, really expanding very quickly. And the weird thing is, also in the new proposal that we have, these things require the minister to act, to hand out an order before exchanges between security agencies were the sole jurisdiction of the agencies themselves. But interestingly, although there is a little bit of strengthening in that process, because again, it now needs to be an explicit ministerial order, that order is not subject to scrutiny by courts. So where we try to be a little bit more politically correct by introducing ex ante involvement of courts in some limited domains, where some people predict the actual growth and also the actual crisis of the rule of law, we still have a system where where there is no oversight, at least no ex ante oversight. And yes, there is a known argument that if you can't get the information directly, maybe there is an indirect way to do that. It's almost a trade agreement between agencies.
That's a good way to say it.
But I actually wanted to touch on something that you mentioned in your opening comments that's sort of related to this, which is that, you said the government is responsible, not the individual agencies. I mean, do we really believe that? I mean, is there not a sense that perhaps agencies take on their own autonomy and run amok?
I think one of the big risks is that we are going to assume a lot of things that we can't verify. I'm just a dumb academic, and I live by the rule that I need empirical evidence. And I do love conspiracy theories, but I need facts and real information. And until I don't have that, I assume that agencies are complying with the law. That might be naive, but I also believe that agencies do need to work under the supervision and the control of the government, otherwise we're completely lost. So it would be wrong to say agencies are just doing what they like to do. I don't think that's factually true. I even have sometimes the idea that certain agencies are overly politically correct because they don't have sufficient legitimation. The system of checks and balances doesn't offer them sufficient comfort for the work that they do. So they have sometimes multiple layers for internal improvement for their work. And maybe this is an image that fits more to the Dutch situation, and maybe in Bulgaria there is a more rogue situation, but basically we have to believe that there is a rule of law that one complies with.
The rest of you are nodding. You all feel the same in your various countries.
I would agree, just one sentence. I really, well, at least from my German perspective, I trust our public servants. from my experience, they really, as you said already, they really want to comply with the law. And sometimes they get more tasks than they can handle or manage, then they have problems. But I also would say this is a question of the politicians, of the lawmaker, of the government, in Germany, and I think in many other states, it's like that drafts of laws come out of the government, not from the legislature body. But the parliament approves very quickly, and I would not put the I would not put the will to or the ambitions to comply with the law. I would not question this concerning our public servants.
Okay. Nathalie, in France, there's no sense that the agencies pressure the government to give them more power?
I think it's really a cultural kind of question. So it depends what type of in what type of esteem you hold your administration, and what's the relationship between the various agencies and the central government. France is still very centralized country in terms of administration, and I'm not aware of big public divergence of views between the government and the agencies. They're merely the agencies execute the orders, basically. So it's not like in the movies where the agencies go their own way, a bit like we see for the US, but obviously all this is quite opaque. It's not entirely transparent. So there might be breaches, not because they had a different view from the government, but just because it happens.
Okay.
Hello, Tobias Morschers from Datenschutzraum Germany. You mentioned how important it is for lawyers to have client lawyer secrecy. My question, going back to the title, is what is about judges and so on in a world where we can see that someone knows a lot about them, and most likely he has something on them? Do we have a problem in very political or economic cases where there may be the independence of the judges itself in danger in any way? There are lots of ways.
Yeah, that's really a fascinating issue. So I looked into some of the National Surveillance Acts, and it's really remarkable to see that there are often special provisions for lawyers and maybe sometimes for journalists, but they are very narrowly defined, where, in my view, the jurisprudence of Strasbourg is or will be that they will look at the function of a person, not whether he is a lawyer by definition, but this is about protected relationships that we have. And normally the scope of these kind of exceptions is much broader than just journalists or lawyers. In some countries there is an extension to, for example, members of parliament. I'm not sure, at least not in the countries that I have looked at, I have not seen provisions that exempt members of the judiciary in general. And there is a big elephant in the room, because normally we also exempt people who have confidential positions based on religion. And that's, of course, where other issues come at the table. I don't actually think there should be no distinction between ordinary citizens, lawyers, journalists, priests, whatever. I think everybody should deserve the same level of protection. And I think that's achievable.
I don't entirely agree with that, yes. It's sometimes you'd like to think that there aren't going to be those sort of compromising issues when it comes to the judiciary. But I mean, even judicial independence has actually been quite heavily questioned in the United Kingdom after we had a decision in the Supreme Court with regards to whether it should be the government triggering Article 50, and there was an awful lot of mud slung at the court and at the judges saying, well, if they were involved in an EU agency at some point, or they're involved in this group, surely they aren't actually able to look at this impartially, and of course they are. They're very highly qualified judges, but sometimes I think there isn't necessarily that level of public acceptance of that or public understanding of that. So I suppose it comes around again to making sure that the public have that level of, and this is where the Law Society needs to help the public to have that level of understanding and information so that they understand why decisions are properly independent, and that indeed the public can have confidence in the basis of those decisions without fear of them having been compromised in any way. But that seems to be an increasingly difficult job.
Okay. Yes, please.
Yes, my name is Debray Kennedy Mayo. I am an attorney in the United States. And I would certainly recommend the FRA report that has been mentioned that talks about intelligence agencies in Europe. I would also recommend a paper that was done at Oxford University that is towards a multinational standard for surveillance reform that talks about the United States and the reforms that have been made since 2013, and also looks at European intelligence agencies, member state agencies, and suggests that the United States is the benchmark. There's been some discussion here today about 12333 and that it is different than the FISA court. The FISA court looks at data that has made it to U.S. soil and provides protections from the FISA court. 12333 looks at information or gathering of information that is outside the U.S. and is done on non-U.S. persons. I'd like to ask the panel, do those type of protections exist from any member state that you are aware of, that a member state such as Germany or France provides protections to individuals who are not their citizens? To individuals who are not their citizens, where that surveillance or intelligence gathering happens not on their soil. So say it happens in Iraq or the United States or China. Do any of those governments provide protections for those individuals when they are not their citizens that you're aware of? Thank you.
Well, for Germany, this question is easily to answer. There's no distinction concerning nationality or having the German citizenship or not. All our legislation refers to all, well, people who are in the country. I mean, of course, it only allows for our agencies to, or our police to survey in Germany.
And let me clarify, the question is, if the surveillance does not happen on German soil, it happens outside of Germany, if it happens in the United States or in Iraq or in China, does Germany provide protections to non-German citizens outside of Germany when they do intelligence?
Okay, oh, sorry, I didn't get this question. I mean, Germany could only provide for, well, let's say help or justice if the case comes back to Germany and the German judiciary would deal with it. I mean, as long as it stays in, let's say, China, of course, I mean, just a practical example, if someone is arrested in China because of results of surveillance, of course the German embassy will try to help, but that's all they can do. And if there's a, let's say, maybe a crime behind this, for which Germany has the competence, it could happen that when the person returns to Germany, that Germany would investigate the case as well. But of course, they would have a very close look at the results of a foreign surveillance. They would not just accept the results. And if this has happened, well, from the German point of perspective, from the German perspective, in an unconstitutional way, concerning the German level, it probably would not be used and would be excluded as evidence. But within the EU, it's far easier to use evidence from other member states.
Yeah, I think basically if there is EU jurisdiction, there is no difference between national citizens and others that are on European soil. When it comes to these kind of presidential orders, this allows me to make a very little remark about where we can find solutions. As you know, the court in Strasbourg has decided you cannot extradite people to the US unless the US guarantees that the death penalty will not be imposed. How is that agreed upon? That's done by an order from, I'm not sure, but it's not law, it's just an order by, I think, the district attorney or whatever Secretary of State. So you can use that level of instruments to come to something that matches Europe with the United States. It doesn't automatically require, let's say, a law as such. Although that's the preference of the court, but if you have something that is similarly effective, that is also possible.
Okay, well, it's almost lunchtime. Thank you all very much for waiting here with rumbling tummies. But I'm going to hand over now, finally, to our chair to make some closing remarks.
Yeah, I think we've had a really good debate covering a lot of these issues today. I'd just really like to thank our panel for having jumped into the breach when we're a man down. But I don't think that has affected the quality of the discussion and the debate during the course of the last hour. So I'd like to say thank you very much for contributing and raising the issues that we've been able to discuss. And I'd also like to say thank you to the audience, because we've had some really good questions. Oh, there we go. What was that? 10 points to Gryffindor, was that? Yeah, so thank you for your fantastic questions. I don't want to get in the way of an audience and their lunch, but obviously, you've got our information here. I'm always very happy to discuss things with people online via email and on Twitter and things as well. So please feel free to continue the discussion online. We've got the Twitter wall going there as well. So thank you for sharing our ideas, and thank you for contributing and making the panel such a success.